Hello friends, in today's video we will discuss about the best form of IPR to protect the packaging. Now best example of packaging is like this. I had this at my home, I am showing you, that's why. So let us say it's a packaging that is protecting the inner content, which may be solid or semi-solid or powdered form also it can be, or liquid form it can be, just like Coca-Cola bottle. Some of the examples of packaging, other examples are Coca-Cola bottle, a jewelry box, a potato chip, canister or a packet, and then a shampoo sachet, it can be a packaging, and chocolate packaging. So these are different types of packaging that protect the inner content inside them in a packet form, or maybe it could be a bottle just like Coca-Cola glass bottle. So these packagings, how can these be protected? See, if it is about the technical thing, maybe you have done something innovative, maybe you have changed the composition of this material, that how material is made, maybe you have made it more plastic free or lesser plastic decomposable, biodegradable kind of a material by changing the composition. That is something different, that comes under the realm of ambit of patents, because that is something innovative you have done. You have found out a solution, very important solution for a very important problem that humanity is facing. Similarly, if you have done something innovative on how to open this up, because sometimes it is difficult to open it up, how to open it up, it's becoming really difficult. Mama, please open it up, I'm not able to. So if you do something that children are able to open it up very easily, and you have made some innovative design for the functional aspects of this packaging, that comes under the realm of patents. I'm not talking about that in this video. I'm talking about how to protect the design of this packaging, how to protect this packaging as a whole, as a design, as a complete packet, or the artistic elements. Or if I just look at this, I'm able to identify the source, just like I look at the Coca-Cola bottle without even any labelings on it, I'm still able to identify that it is coming from Coca-Cola. The source, the inner contents of these bottles are from Coca-Cola company. So how to protect the designing part? So for that comes the importance of other different intellectual property rights, which are trademarks, copyrights, and industrial designs. But there is a big confusion that under which of these should we protect our packaging. Should it be industrial designs, or it should be copyrights or trademarks? Because all these three make eligible packaging to be protected under them, depending upon the intended use, depending upon the unique features of the design you want to protect, and depending upon the long-term business goals of yours. You need to choose the best one out of trademarks, industrial designs, and copyrights, because the features which they protect always overlap, and so a decision needs to be made, maybe with the personalized consultation, in-person consultation with an attorney or agent, that which one is best for your business goals. But to make it easier for you to decide, it's good if you watch this video, because as a general video to educate you that how can you direct yourself for this decision, let us understand these three types of IPR with respect to a packaging. Coming to the first one, which is trademarks. Trademarks not just protect a logo or a name, brand name, but they also protect some other important identifiers that distinguish the products or services in the marketplace. Those are the identifiers which help you identify the brand, from where the source from which that product is coming from. So just like Coca-Cola bottle, when you see the Coca-Cola bottle, even without labels or the company name written over it, brand name written over it, you are still able to identify through the shape of that bottle that yes, it is from Coca-Cola. The contents inside it are Coca-Cola company's Coke. So the point is, when you want to use your packaging as something which is used to identify the source, as a source identifier for your business, then if the agenda is this, if the intended use is this, if this is your business goal, then the best way to protect your packaging is trademarks. So trademarks, because they protect the identifiers of your business, of the source, if the intended is purpose to use the packaging is in that way, the intention, long-term goal is that, then the best way to protect packaging is trademarks, because trademarks do protect 3D shapes and packagings as trade dress. We call it trade dress. Now coming to the second one. Now if the intention is not to use it as a source of your brand name or something like that, but the intention here is to protect the artistic elements, even not the product. You want this printed form which is over on the front side, this print, how the balls are positioned, this yellow portion within these circular areas, and this red portion here, this yellow portion here, this expression of the ideas put by you as a designer. So the graphic designs, the label layouts, the artistic elements, these types of things, how the artists has put all the things together, then that thing is protected by copyrights. Copyrights protect the original works of authorship. So when the intention is to protect the creative aspects of packaging, and what I mean here is, even if this is not a packaging and we put this front design on a piece of paper, then actual intention is to protect the design as such, the artistic elements, and not the packaging as such. Then the best form of IPR to protect it is copyrights. And even the best part to note here is that copyrights protect you, provide you, protection for 60 years, even after the death of the artist, death of the applicant. So this is a long time protection which even doesn't require any renewals. That is the best part of it. That's why people go ahead with copyrights much more than the industrial designs or trademarks. And there are some rules by government, some sections by government to stop this or reduce these things also. I will discuss about this after I define the last one, which is industrial designs. Then why and when can we use industrial designs? See, industrial designs protect the appearance of the product packaging. Appearance in the sense, the shape, the boundaries, how the 3D shape is prepared. So the whole appearance, and if I say appearance, I mean shape, I mean configuration, that how the things are arranged. Like this is the zigzag on the upper side, and it is sleek towards here, sleek towards here. Again, this one is again a curved portion with some zigzags at the bottom. So how is it configured? Plus the ornamentation, which is decorative elements. Decorative elements also cover these things in the front and the back. So that is protected by industrial designs. Industrial designs protect the overall, important word here is overall appearance of the product, not just the artistic elements, but overall appearance of the product. That is protected by industrial designs. So any out of these three can be chosen to protect your packaging depending upon your intended use, unique features of the design that you want to protect, and your long-term business goals. Next, but there is a need to discuss some conflicts that may arise between trademarks and copyrights, and between industrial designs and copyrights with respect to a packaging, because the elements, the features protected that could be protected for a packaging do overlap. So we need to discuss this. Coming to, you see, people usually choose copyrights because they provide long-term protection 60 years after the death of the person even, and there is no renewal which is required. But in case of trademarks, we need to renew it before every 10 years for the next span of 10 years. In case of industrial designs, it is for a limited period of 10 years and extendable up to 5 years, so it is up to 15 years only. So that is why general public is more convinced with copyright protection. So that is why there is a need to address some conflicts between trademarks and copyrights and industrial designs and copyrights. For trademarks and copyrights, there is section 45, which says that if there is some good or a service that is eligible to be protected as a trademark, this could be one of them. If there is a good, which could be packaging also, because it is a source of, it's an identifier for a brand which can be used. So it's a trade dress. So if some identifier could be protected as a trademark, but it is chosen to be protected as a copyright, then for those goods and services, there is a need to prove that you have not filed a copyright, if you have not filed a trademark for it, by providing a certified search proof by the trademark registry, which costs you 9,000 rupees usually. Along with this, the normal copyright fees, which is 500, is now 2,000 when you file copyright for artistic works which are eligible to be protected as a trademark also, but are not chosen to be protected as a trademark. So this is under section 45, which needs to be addressed and discussed for your specific product with your agent or attorney. Second conflict between industrial designs and copyrights is provided by section 15 of Copyright Act, which says if something is eligible, with some packaging maybe, is eligible to be protected as an industrial design, but it is protected as a copyright for whatever reason it be, but it is an industrial design which is used for commercial purposes, and hence it should have been protected as industrial design, but it is now filed for copyright registration. Then once you develop 50 copies, once you manufacture or once you sell or do anything related to commercial aspects for 50 copies of it, for 50 versions of it, then after that the copyright in it lapses, ceases. Copyright doesn't exist anymore. And if something which is copyrighted, okay, this is one part of that section 15, that once it is manufactured or sold 50 times, then after that copyright on it ceases. Another thing to be noted is, if you have protected it as a copyright, but then for whatever reason after some time you file it as an industrial design, then automatically the copyright registration over this same thing ceases. That means you can either have a copyright over it which ceases after 50 copies reproduced, or you can have an industrial design after which this copyright automatically ceases. You cannot have both at one time. So these two sections, section 45 and section 15, address the conflicts copyrights may have for a packaging in case they are eligible to be filed as a trademark or as an industrial design, which should always be discussed with an agent or attorney for your specific product as and when there is a need. I hope you like the video and I am able to educate you and make you more informed about how a packaging design can be protected. Thank you so much for watching the video.